Hi there. Good afternoon, everybody. My name is Chris Justice, and I am an employment lawyer with Samfiru Tumarkin. As always, I'm here today to answer hopefully as many questions as I can from you all things to do with employment law. So if you're watching, you're listening, definitely get your question in. Maybe it has something to do with a document that you've been asked to sign, and you've got some questions about that. Could be maybe an issue you're dealing with one of your bosses or colleagues, coworkers, and you may have some questions around that. Or maybe you've just been let go and you're wondering about how much severance might be appropriate in your case, and there might be other issues at play. So whatever it is, get your questions in and we'll do our best to answer them live here today. As I normally do at the beginning of each session, I like to kind of bring up maybe some topics that are circulating in the news. Or some recent experiences that I've personally been dealing with at the firm myself. So I wanted to start today with one sort of topic that was hitting the news, and that had to do with the CEO of the company Astronomer getting caught on camera during a Coldplay concert. Now, without getting into the specifics of that case or that situation, it did raise the issue of workplace relationships. So I thought it would be good to talk more generally about how workplace relationships work, whether they would expose, say, an employee to possible liability, whether you can be let go or fired for being in a relationship like that. So just to start, though, generally speaking, from a sort of inherent or general perspective, there's nothing necessarily wrong with a workplace relationship. However, it can sort of get people into hot water in certain situations where there's specific context. So, for example, if you're in a relationship with someone that you work with and you have a position that is going to be higher than them, there could be the suggestion that there's pressure or duress on the subordinate, the person sort of lower in the company hierarchy, and there could be questions as to consent. So that's one thing that could potentially come about, especially when there is more of a power imbalance. Another thing that comes about when it comes to workplace relationships and where people can get into hot waters where maybe due to the relationship, there's more bias. There's obviously going to be perhaps a deeper relationship or type of connection between these two people. So when it comes to maybe them both evaluating their performances, of course, there could be the perception at the very least that there's going to be bias, that those evaluations are not going to be purely objective, and there's going to be a lot of subjectivity to it, which can then lead to further instances of bad faith, deception. So it's a lot of times what flows from the working relationship that can cause issues, especially where there is that power imbalance or where the issue of bias becomes more prevalent and has a real effect on the future of someone's employment, say, at the company. And I think for these reasons, for these potential risks, it's always important for companies to, knowing that this is a possibility, establish policies around workplace relationships. Now, I wouldn't normally suggest that a company implement a straight out ban of all workplace relationships. I think that can have the effect of sort of pushing them underground, so to speak, where there's now an environment where people have to hide things or may hide things, and that can become a problem, I think, in general for the company. But there at least does need to be certain limitations or guidelines put on employees when it comes to certain workplace relationships. So one common policy or sort of a term in a policy that I see a lot of is that the relationships or certain relationships at the very least have to be disclosed. So again, say if it's a manager in a relationship with a subordinate, and there is that power imbalance, there is that perception there of something that could potentially go awry. It would be in those cases, as an example, that you would want to have disclosure for sure, so that at least the company's aware. Because again, there's nothing inherently wrong about them. but because of potential consequences that flow from them, disclosure in a lot of cases can be seen as a reasonable policy to implement. If you're a company and you don't have any policy on this, I think it's worth your time to get some legal advice as well from the employer's perspective to implement a policy. And that's something that our firm also has dealt with in the past in terms of drafting up certain policies, whatever they may be, including one like this. So that's sort of one thing, that the policy needs to be created. There are certain risks that can be at least reduced or eliminated by putting forward a policy, and then at the same time, again, not have there be an outright blanket ban on these types of relationships. Now, a lot of people have also asked me if they are in a relationship that they have maybe disclosed or they haven't disclosed, and the company finds out, can they be let go? Can they be fired on the basis that they're in a relationship? And so, from a general perspective, and I say this a lot, a termination can happen for almost any reason you can think of. It's not illegal or offside in a sense to let somebody go if you find out there's a relationship. However, if you are let go for this reason, there's still going to be a very good chance that you're going to be entitled to severance. So as much as it may be possible for employers to let you go for almost any reason they want, as long as it's not, outright discrimination, like extreme bad faith, they have to pay you an appropriate amount of severance. The only way that I think an employer could use the relationship to establish cause for termination is if, in addition to being in that relationship, there was the strong evidence suggesting that there was bias, that there was bad faith, that there was a lack of objectivity, that there was a relationship that may be not based on consent. There may be a situation where there's pressure. So I think it can essentially turn into a termination for cause, depending on how deep you go. But just for the fact of having one, even if it hasn't necessarily been disclosed, is not going to usually be enough to justify cause. And so you would be looking at severance. And so if you're in a situation like that, let's say, and you've been at a company for 2 decades, and you've entered into a relationship, company found out, you were let go on the basis solely of being in that relationship, you could be looking at upwards of 2 years of severance, given the amount of service you've got with that company. So your entitlements and your rights can still be quite significant. But in general, you want to try to avoid, of course, those particularly bad scenarios where there is that influential factor. And I think it's just a cautionary tale, I think, for both employees and employers alike. But with that said, I will get into some questions just before I get into some of the other topics that I had in mind in terms of discussing off the top. So the first question comes from Melanie on Facebook, who's saying that the owner of the business they work for hasn't paid rent for several months, and now the landlord has changed the locks, which has essentially cost all the staff to lose their jobs without warning. No severance is being offered, and Melanie's asking what their rights are in this type of a situation. So, I mean, there would be a general concern as to the finances of the business. Obviously, this person's not paying their rent, the locks get changed, and essentially everyone's now without a job. Well, first of all, you lose your job in a scenario like that, you're going to typically be owed severance. You weren't given any notice, so there's not going to be any notice that the company can rely on to its credit. And so all that means is, generally speaking, that you're just going to be owed more pay or severance in lieu of that notice than otherwise may have been the case. Even if a company goes out of business or shuts up shop or closes its doors, and it sort of tells its employees that because it had to close up that they're not owed any severance, that's not a reason for why someone is not owed severance. You're still going to be owed your severance. The only situation where your severance entitlements may be limited, not necessarily eliminated, but limited, is if the company can provide solid evidence for being in basically a state of bankruptcy or insolvency, where it may have, hundreds of thousands of dollars of debt, when compared with the assets of the company are going to be completely outweighed by the debt itself. And so sometimes companies file for bankruptcy, they go through that insolvency or bankruptcy process. And then depending on what money may be left at the end of that process, that money is usually distributed to potentially employees, but also other creditors, places like banks, lending institutions. So that's the one-off scenario where maybe if you've been let go, or the doors have been closed, or the place has been shut up for shop, that you may not get as much. But in most cases, when things like this happen, it does still mean you're going to get your severance. Oftentimes, I've gotten severance, full severance for people in scenarios like that. And that's a situation where you should definitely give us a call sooner rather than later, just so we can kind of get a bit better of a background on the situation itself, and give you advice as far as what your potential severance entitlements are. Because, as I was saying earlier, if you've been at a company for a couple decades, you could be looking at upwards of 2 years of severance. But even if you're only there for a year or two, there are also cases that show people in those situations should still get 4, 5, 6 months of severance. So don't think that even if you're there for a short period of time, regardless of how it was that you lost your job, that you don't assume that you're not going to be owed a lot, because even those shorter service employees are getting disproportionately larger packages on their way out. I've got another question in from Bet on YouTube, who's saying that at their old job, they would get paid on the 15th. They had planned on quitting the day the money was deposited because they had to immediately begin another job at a different company. Okay, so you're going to work to the 15th, get paid, quit as of that day. We receive our pay on the 16th, which was the last day of work. So technically I worked 2 days into the next pay period, which would be the 15th and the 16th. I left my resignation letter as well as my recorded hours, but I haven't heard anything from them. I don't think that they will pay me for those 2 days. Is this illegal? Is it worth taking further? So assuming they accepted your resignation, I don't know what their view is on your resignation. Sometimes they accept it and they say, yep, no worries, your last day is the 16th. In which case, if you've worked those days, absolutely, you should be getting paid. And if you don't get paid, then that would be essentially wages that you'd be owed under the legislation. That may be something that you can help secure with the help of a lawyer, or possibly even go through the Ministry of Labor, although I would definitely tell you to call us first so we can decide what the best course of action there is. So yeah, if the company accepted the resignation, it was understood that would be your last day, then you should 100% be getting paid for those days. Sometimes there are scenarios where an employee resigns and they don't give the employer enough notice of the resignation. And so a lot of times we hear of the phrase wrongful dismissal, because that usually refers to a situation where someone's maybe lost their job, haven't been paid severance, or maybe they've been constructively dismissed, these being examples of wrongful dismissal. But there also is a term known as wrongful resignation, where in a very few, to be fair, very limited set of circumstances, an employee is actually required in some capacity to give a certain amount of notice before they resign, particularly more senior employees, maybe employees up high in the director sort of level or higher, employees that if the company loses, the company's going to need maybe a bit more time or ability to focus on trying to replace them. And so in some scenarios, an employee can sort of leave immediately without any notice. And there may be something, for example, in the employee's contract that will say you're to give us X amount of weeks of notice. And you could be in breach of that possible resignation clause in your contract. So technically that's a separate issue in terms of, you working those 2 days and should be getting paid for those 2 days. But if you've got something in your contract that says I need to give the company 2 weeks notice or 4 weeks notice or whatever, there is the potential that the employer, the company that is, if they don't get that notice, could potentially come after you for sort of damages that may represent that resignation notice period in your contract. So it doesn't happen often, a lot. I say this just to say it's a possibility. But just so those out there know, sometimes you are obligated to give a certain amount of notice, and so you can leave your employer a little bit in the lurch if you don't give them that notice. Normally, even if you don't, I find that a lot of employers aren't probably going to bother with going after the employee for that money. But if you are someone who maybe earns more, someone who's in a more senior role, maybe someone who has a longer resignation notice period, that may be enough for the company to potentially take action for you having done that. But I would definitely give us a call, Bet, and just fill us in a bit more in terms of your situation. I'm absolutely sure we can figure out what the best course of action for you there is. I've got another question in from Caro, who's saying that they had returned from a parental leave, but when they came back, the position was basically hollowed out. So most of the duties of staff have moved to other managers. Is there anything I can do? And Caro adds, it seems like they're paving the way to let me go. Yeah, that could definitely be a possibility. I'm assuming when you say essentially hollowed out, you're basically saying that the position you've come back to is really just a shell of what it used to be. So maybe before you went on your paternal leave, you were responsible for 10 things, and then you come back from your parental leave, and you're now only responsible for 2 things. And so they basically just strip you of a lot of your key duties and responsibilities, which is typically a breach of contract. It's normally considered a breach of the terms of your employment. You signed up to do, A, B, C, and in exchange, you will get paid X, Y, Z. But if they, without your consent, just say, you know what, you're only going to be responsible for A now, you're not going to be doing B or C, we'll still pay you X, Y, Z, but you're only going to do a third of what you did before. That can still be a constructive dismissal. And it can be a way that I find a lot of companies do try to push people out, because you might get frustrated. You may think, this is not what I signed up to do. I'm leaving. And then it potentially gives the company an out to say, okay, we'll accept your resignation. And then they avoid further liability. Maybe they get away without having to pay you any severance, when it all kind of originated from their breach. So you don't want to be going to them saying, I quit or I'm resigning. But it is a concern to see that they've basically had you come back to a shell of your former role. Normally, the starting idea would be, okay, see if they will give you back those duties. Try to understand, I guess, best you can. This is what I was doing before my leave. Now I've come back. It's like night and day. This is what I signed up to do. I want to do this. I'm not agreeable to this. So what's going on here? Am I going to be getting back my position? Is this a change that's going to be indefinite and just apply for the future? So sometimes it's good to try to at least get some clarification without saying your view or your position on it, just to try to understand how long is this going to happen? What's the reason for this? And maybe just get them also to acknowledge that it is a significant change. In some situations, they may back off and give you what you want, and that might be in your best interest. You may not necessarily want to leave, but if you've tried that, or if a lawyer on your behalf has tried that, but essentially to no avail, because the employer is just saying, look, it's our way or the highway, you either do this or you don't, then at that point you could justly say that you tried to get clarity. Maybe you tried to get them to reinstate you back to that role. They've said pretty clearly they're not going to. Maybe there's a record of it, and that you're treating this as though you've been let go. The breach of contract, a constructive dismissal, and potentially going after them basically for the severance that you would be owed had they just simply said, we're letting you go. But again, before having any conversations into too much depth with your employer, I would definitely tell you to give us a shout, just so we can kind of guide you through that process. But yeah, it does look like a scenario where they're trying to push you out. And unfortunately, a lot of people just end up leaving, not understanding that they may have rights, and they may be able to sort of take certain actions that put them in a position where they can get some money for the time or the years that they put in with that organization. I've got another question in from Tarazo, who's saying, if you have an employment contract that states the company owns things that you've developed, how far does that go? If I'm building an app in my own time, does the company own it? So That's something that does show up in a lot of employment contracts, depending on, I guess, the industry that you're in. It is delving a little bit into intellectual property law, IP law, so that would deal with things like patents, trademarks, copyrights. I know there are scenarios where even if you develop something on your own time, say you work a 9 to 5 and you develop an app from 7 to 10 of that night, or during those hours of the week, depending on how you develop it, what tools you use to develop it, especially if it's the company's tools, that would be a potential overlap where the company may be able to claim some ownership on it. I think the fact that you have a contract that says the company owns certain things under certain guidelines or parameters, depending on what that specifically says, word for word, that could also capture in the time you're using to build an app, and they may lay claim to it for that reason. So I would definitely want to look at the contract to understand what it said. But also, even if it's not necessarily written down, there still could be a situation where you used the company's confidential information or tools or whatnot, or something you may have learned specifically because you worked for that company that you wouldn't have known about otherwise to build this other app, even if it's off hours. Again, there could be an overlap in terms of how is it that you built the app? Is that something you could have built regardless of whether you work for this company, regardless of any of the information you may have come into contact or possession with? But it does get, like I say, into the IP law realm. So just because that's not my wheelhouse, I would potentially refer you to an intellectual property lawyer. But it may also involve looking at that contract. That might give us a better idea in terms of what they're trying to capture. So if anything, give us a shout. We can at least set up a consultation to talk about your matter, and whether we can help you or someone else can help you, we can certainly get that done and just make sure going forward, you know, kind of what the situation is. I've got another question in from Ali, who's saying they were reprimanded for talking with a coworker about their salary. I thought we were allowed to discuss this, is the question. Can an employer punish you for talking about your pay? So an employer can sort of, I'll say, punish you for talking about your pay. Whether or not they would be able to use that as a way to get rid of you and not pay you any severance, that's a completely different question. The fact of the matter is that an employer could let somebody go just because they don't like the color of their shirt. It's not the best reason at all to let somebody go, but it's also not illegal to do so. So I think it just depends on where the employer's going with this, and also how the employer is punishing you. Because it could be a problem, for example, if the employer, let's say, found out you were talking about salary with a coworker, and then your employer says, we're going to punish you, we're going to suspend you, we're going to put you on a suspension, you're not going to work for the next 2, 3, 4, 5 days, and you're not going to get paid either. So it kind of depends also on what the punishment is, because there could be, of course, a number of punishments where they've gone too far. Or it could be maybe something on the lower end where they give you a verbal warning or something. Maybe in the warning or the reprimand, they refer to a policy of theirs. I'm not sure if there's some sort of booklet or policy that speaks to these issues, or what exactly the employer's problem is. Because talking about salary is one thing, but it's all about context too. You could have, an employee group meeting in private in an office somewhere where you're sort of rallying the troops to create a union that originated from a discussion about salary. So context, like I say, is important as well, just to give a better understanding of what the problem the employer has with it is. But like I said before, if they're going to use this and try to build a case against you to let you go and say, you know what, we're letting you go for cause, we're not paying you a dime on your way out, that's a lot of times where employers go way too far, and that's where they can get into a little bit of hot water. I've got another question in from Jim, who's saying they reached out to the Canada Labour Board almost a year ago and still not have received a response. Should I reach out again? Yeah, absolutely. I mean, if I If you're not getting a response after a year, I would be looking at phone numbers, maybe fax numbers, email addresses. The other thing too is that depending on what your matter concerns, what you've exactly gone to the Canadian Labour Board about, you may want to speak with a lawyer, because there may be a situation where you're running out of time, for example, to file a lawsuit or go after a former employer for certain rights or entitlements. So I'd be just concerned about making sure I don't miss any deadlines in terms of possible avenues I could go down to deal with my matter or my concern or issue. But yeah, otherwise, without further context, I don't know why they would be taking a year. It is a bit strange. I know that they do tend to take some time. So it may also depend on what exactly you're waiting for a response on. And I think with some more information, that could be something we could sort of tell you maybe that is okay or not okay, something you need to follow up on or not. But yeah, generally speaking, I would say try to get in touch with somebody, a representative over there, just to get a sense of what's going on. And failing that, give us a shout and maybe we can talk about it in a little bit more detail, and just sort of figure out if you've crossed all your T's and dotted your I's and that you're not missing any of those deadlines, like I said. I've got another question from Carol, who's saying that they're on short-term disability leave due to workplace harassment. The day after they started to leave, the company posted a position that they were told they were being groomed for. What are my rights? So being told that you're being groomed for a future position, when I hear that, I think, well, is there something in writing? Because if someone comes to you and says, yeah, I think you're going to be good for this position that's coming up, unless it's in writing and agreed to, it's going to be hard for you to hold that employer to that promise. If there even is a promise that was made. So I guess the question is, being groomed for, does that mean you were told, without any uncertainty that you will be getting a job by a certain day, or just that you are, maybe in line potentially for a job, which is obviously not going to be solid enough to build any contract or sort of set terms in that sort of scenario. Now you're on STD, you go on the leave. I guess the other question would be, how long are you going to be on leave? Is this going to be something that could stretch months, maybe years? Because, there does come a point in time where a company has to look after itself as well, maybe need someone in the position that you're being groomed for, and may have to hire somebody. Usually when you go on a leave of absence and you come back, you're typically going to be guaranteed your same job or something similar. So if you do come back from the leave that you're on, the only obligation the company would have, unless again you've got something in writing or some kind of new contractual terms agreed to, is to return you to the job you had before you left. Now, if you come back to that job and then later find out that there's someone in that position that you're being groomed for, and that realistically you're probably not going to get it anymore, if that was never a job that you were guaranteed to begin with, there probably isn't anything inherently wrong or off base about the company doing that. It would be frustrating, I know, because you'd be losing that possibility of that job that you were maybe looking forward to doing. But generally speaking, unless there was a contract signed or some deal struck, companies can sort of unfortunately drag people along with these promises for however long they want. You just need to get it solidified. Because if it doesn't get solidified over time, especially if it's sort of a loosey-goosey thing where they haven't committed to a date or anything in terms of when that job will be had, then there's not going to be much you can hold them to. Now, on the other hand, if you can show that you lost that position that you were being groomed for because of the fact of going on a leave or bringing forward a harassment complaint, and you can kind of connect it that way, that's going to be very problematic for the employer. That could give you some options as far as what you want to do going forward, or what you can possibly get out of it. But that's also a tricky thing to prove in most cases. So it'll just depend. Again, I would say this is a situation probably best delve a bit more into in a consultation, and make sure that we give you the proper advice moving forward. But having said that, that's going to do it for my time today. I do thank everyone for their questions. I will be back, as I always am, in case those still have questions that I haven't been able to answer. But we also have other shows going on with other lawyers at the firm all the time. So for those that didn't get their questions answered, for example, we've got down below there Thursday, July the 24th. So just a couple days in the future with Jeremy. So do tune in then and absolutely get your questions in. Otherwise, for those that I mentioned getting a consultation for, absolutely give us a call. We'll hook you up with the right lawyer you need to be talking with, and we'll do everything we can to help you out. But thanks again for your time. Do enjoy the rest of your Monday. Thanks all. Take care.